Chapter 1 Preliminary Section 1 to 4. A person who dies without making a will is known as intestate. This has been defined under Hindu Succession Act in Section 3G. Section 3C of Hindu Succession Act defines cognate. If a person are related by blood or adoption wholly through male, each one of them known to have agnate to other. Here has been defined under Section 3F of the Hindu Succession Act. One person is said to have agnate of another if two are related by blood or adoption, but wholly through the males. Agnate is a person who is related by blood or adoption, wholly through the males. A person is said to have been cognate of another if two persons are related to each other by blood or adoption, but not wholly through the male. As per Hindu Succession Act 1956, two persons are said to be related by each other by uterine blood when they are descendant from common ancestral but different husband. Presumption that the younger survived. The earlier under Section 21 of Hindu Succession Act 1956 is rebuttable presumption of law. Co-partnership property is known as joint family property. Chapter 2 Intestate Succession Section 5 to 29. Which one of the following section of Hindu Marriage Act 1956 makes provision for notion partition? Section 6. The Hindu Succession Act as amended in September 2005 empowered the daughter of co-partnership right in co-partner property like son under Section 6 of the Act with effect from 9/9/2005. The Hindu Succession Act 1956. Which one of the following is not a class 1 heir? Father. Under Section 8 of Hindu Succession Act 1956, the correct order of priority of succession is reflected as following: Class 1 heir, Class 2 heir, agnates, cognates. When a Hindu intestate of property from his father under Section 8 of the Act, he take it as his separate property. Rule 2 under Section 10 of Hindu Succession Act 1956 is a per capita rule. The rule regulating the distribution of property among heirs in Class 1 of the schedule, the Hindu Succession Act 1956 contained in Section 10. Under the Hindu Succession Act 1956, the case of intestate succession of a Hindu male father is Class 2 heir. Which one of the following is correct under Section 10 of Hindu Succession Act 1956 for surviving son, surviving daughter, mother, and male intestate? Each shall take one share. The rule of distribution of property of intestate among heirs in Class 2 of the schedule have been provided under Section 11 of the Hindu Succession Act. Under which section of the Hindu Succession Act 1956 a female Hindu is declared to be full and absolute owner of the property possessed by her? Section 14. For the application of Section 14 of Hindu Succession Act 1956, the acquisition of the property by a female Hindu must be either prior or after the act came into the force. The proposition of law laid down in Thalluswamy versus Sesa Reddy, AIR 1977, related to right of female Hindu under subsection 1 and 2 of subsection 14 of Hindu Succession Act. Section 14 of the Hindu Succession Act 1956 applies to both movable and immovable property. Under Section 14 of Hindu Succession Act 1956, any property possessed by female Hindu, whether acquired by her before or after the commencement of this act, shall be held by her as a full honor. V. Thalluswamy versus V. Sesa Reddy is a leading decision of Supreme Court on the provision of Section 14 of the Act. The general rule of the succession in the case of female Hindu are contained in Section 15 of Hindu Succession Act 1956. The general rule of succession in the case of female Hindu have been laid down in Section 15 of the Hindu Succession Act 1956. The property of Hindu women dying intestate shall devolve firstly upon sons and daughter of the husband. Under the provision of the Hindu Succession Act 1956, any property inherited by the female Hindu from her father or mother shall be devolved, in absence of any son and daughter of the deceased, including the children of any predeceased son of the daughter, upon the heir of the deceased female Hindu's father. Which Law Commission report has proposed to amend Section 15 of Hindu Succession Act 1956. In a case female dies intestate, leaving herself acquired the property with no heir. 207 Law Commission report. Under Section 20 of Hindu Succession Act 1956, the right of children born in matrimony have referred to moment of conception. The provisions of which section of the Hindu Succession Act 1956 deal with the presumption in a case of simultaneous death. Section 21. Presumption in a case of simultaneous death under Section 21 of Hindu Succession Act 1956 is that younger survived the elder. A transfer made in the violation of Section 22 of the Hindu Succession Act 1956 is voidable. Section 23 and 24 of Hindu Succession Act has been omitted by the Amendment Act in 2005. Which provision of Hindu Succession Act 1956 disqualifies a Hindu to inherit property of the person whom he is convicted of murder? Section 25. A person is not disqualified from succeeding to any property on the ground of any disease defeat or deformity is provided under Section 28 of Hindu Succession Act 1956. The separate property of Hindu male dying intestate is succeeded by mother. A. A Hindu has two wives, W1 and W2, and one son, S, by the wife W1 and the four sons, S1, S2, S3, S4, by wife W2. On partition of co-partnership property, W1 and W2 will get 1/8 of the share. The Hindu Succession Act 1956 mentions two types of heir of Hindu male who is not a class 1 heir under Hindu Succession Act. Father. Regarding being had to be provisions of Hindu Succession Act 1956, which one of the following statement is not correct? D is not correct. Which one is correct? If a Hindu woman had any existing interest in the property, howsoever small, prior to the enactment of the Hindu Succession Act 1956, the same would be blossomed into full-fledged right by the virtue of operation of Section 14(1) thereof. The right of daughter in co-partnership property is not lost by passing of preliminary decree for partition before the 20th date of the December 2004. If the right is created in a Hindu female for the first time in respect of any property under any instrument or under a decree where the restricted estate in such a property prescribed, the provision of Section 14(2) of above Act would be attracted and would not be converted such a right into full-fledged right of ownership of the property. If a woman who had inherited property from her mother dies without children, then such property devolves on her heir of her father. Which section of the following of Hindu Succession Act 1925 treats agnates and cognate and a male-female heir equally? Section 27(1)(a). By 2005 amendment of the Hindu Succession Act 1956, a son is liable to pay which one of the following untrained debt procured by father before the amendment in the Act? A is Hindu male. He died intestate, leaving behind two grandson M1 and N of deceased son C and three great grandson X, Y, Z of the deceased son P of deceased D. What will the share of M and X? M will get 1/6 and X will get 1/9. A Hindu male having undivided interest in Mitakshara Kopashnari property dies leaving behind two sons and one daughter. The daughter is entitled of which one of the following share of the property? 1/3. Under Mitakshara school, Kopashnari interest devolved by survivorship. When during partition of a family or it is agreed as a family arrangement to maintain the mother, then his contract is valid and enforceable. Which which of the following relation is one of the four relation which has been evaluated to class 1 heir category by the Amendment Act of 2005? None of the above. Alienation by Karta without legal necessity or benefit of estate is voidable at the instant of the co-partner. Principle that subsection 2 of section 14 is more in nature of proviso of exception of subsection 1 was laid down in Naraj Singh versus Jagjeet Singh, Nazar. A Hindu dies intestate, leaving a son and two daughters. His property was partitioned. Whether each one of the successor is entitled to alienate his or her share without the consent of other heirs? Yes. Consider the following. A. A Hindu widow who has inherited the property from her father-in-law dies issueless intestate. That property shall devolve upon the heir of the husband. Under Hindu law, a karta of a joint family can alienate the property for both legal necessity and benefit of estate. Testamentary succession related to Hindu Succession Act. The property acquired by female as a co-partner can be disposed by her by way of testamentary disposition gift. Hindu Succession Act. A Hindu widow ex got property in succession from her mother. X dies intestate. She leaves after her a brother and her husband's father and mother. Her property will be devolved upon to her brother. Hindu Succession Act. A. The only son of B and co-partnery in joint Hindu family governing by Mitakshara law murdered B, whose die intestate, who will succeed the property of B, state government. After the Hindu Succession Act, Hindu Succession Amendment Act 2005, the daughter of the co-partnery in joint family governed by the Mitakshara law shall become a co-partner by birth in her own right in the same manner as the son. After passing a decree for the judicial separation, if one of the spouse dies intestate, the other spouse can inherit the property of that spouse. Chapter 3. Testamentary Succession. Section 30. Under Section 30 of Hindu Succession Act 1956, a Hindu disposes of his interest in Mitakshara co-partner property by a will. Section 30 of Hindu Succession Act 1956 authorized a Hindu dispose by will his self-acquired property, undivided share in Mitakshara co-partnery property. Chapter 4 repeals. Section 31 Schedule. Who among the following is not a class 1 heir? Brother. In the absence of class 1 heir, who inherit the property of Hindu male? Father. Which one of the following is not a class 1 heir under Hindu Succession Act 1956? Father. Under Hindu Succession Act 1956, which one of the following is not a class 1 heir? Father. Son. In class 1 heir, class 1 of the schedule of the Hindu Succession Act 1956 does not include stepson. Which among the following is not class 1 heir under Hindu Succession Act 1956? Father. Where a Hindu male dies intestate, leaving behind the ascendant agnates and descendant agnate, the collateral agnate, their order of succession on preference basis shall be descendant, ascendant, collateral. Order of succession under Hindu Succession Act of a male Hindu dying intestate is following: class 1 heir, class 2 heir, agnates, cognates. A Hindu die intestate, leaving behind 2 sons, 1 daughter, and a widow. His property shall devolve upon son, daughter, widow. Under Hindu Succession Act 1956, who among the following is not a class 1 heir? Father. Father's widow is a class 2 heir. A mother is not entitled to inherit class 1 heir from her stepson. Which one of the following statement is incorrect in reference to Hindu Succession Act 1956? Daughter is here in class 1. A Hindu widow A inherit property from her mother. A dies intestate, leaving behind her brother, her husband's father, and mother. The property shall devolve upon her brother. Hindu Succession Act. A Hindu dies intestate, leaving 2 sons, 3 daughters, 2 widows, 3 granddaughters by a predeceased son. Calculate the share of the granddaughters. 1 by 24th. Which one of the following pair is correctly matched? D. Father is class 2 heir. A Hindu has 2 wives, W1 and W2, and 1 son, S1. By Hindu wife W1, by a wife W1, 4 sons, S1, S2, S3, S4. By W2. On the partitioner of co-partitioner property, W1 and W2 will get 1 by 8 of each share. Miscellaneous. A Hindu, during substance of the marriage, solemnize second marriage without obtaining decree, who are not entitled to grant succession. Certificate on the death of A. Second wife. Failure of one branch of the family to question of validity of an alienation in suit would be bar the right of the other branch. After the institution of suit for partition by a member of the joint family, there is no effect in the share by the virtue of birth and death. As a general rule, interest in co-partnership property is acquired by the virtue of birth. Hindu Succession Amendment Act 2005 came effect on 9 September 2005. A joint Hindu family does not include married daughter. As a result of change introduction Introduced by Hindu Succession Amendment Act 2005, the daughter of Kopasnari in a joint Hindu family governed by Mitakshara law became Kopasnar with effect from 9/9/2005. Honum Prasad versus Musmat Bibi is a case on powers of Karta of a joint Hindu family. The alienation of the property without the permission of High Court is valid. Karta of a joint family property is father. Hindu Succession Amendment Act 2005 conferred upon a Hindu woman right to claim partition, right to ownership as a co-partner, right to reside the partition in parental dwelling house even after marriage. After the Hindu Succession Amendment Act 2005, the daughter of a Kopasnari in joint Hindu family governed by Mitakshara law shall become a Kopasnari by birth in her own right as the same manner as the son. A Hindu dies intestate, leaving behind 2 sons, 3 daughters, 2 widows, 3 granddaughters by predeceased son. Calculate the share of granddaughter 1/28. Which one of the following statement is not correct in respect of Hindu Succession Amendment Act 2005? The amendment is retrospective in operation. A dies intestate, leaving behind 2 sons and wife. Wife was pregnant at a time of A's death. The wife gave birth to the male child after 7 months of A's death. The child inherit with effect from the date of A's death. Property acquired by male under the Hindu Succession Act 1956 is his separate property. A Hindu family consists of father F and his 2 sons S1 and S2. In a sudden fight between S1 and S2, S1 killed and the later father died. S2 is entitled to entire property of F. How? He must be totally disqualified. A Hindu joint family consists of the father F and 3 sons S1, S2, S3. Converts to Christianity in 1960. S2 suffering from leprosy. F1 dies in 1961. Who is here can inherit the property of F? All 3 sons.